We are good to go, senior.
Bharat, you can start. Proceed.
Yeah. As, as spelled by Dr. B.R. Ambedkar once, however, a good constitution may be, if those who are implementing it are not good, it will prove to be bad. However, a bad constitution may be, if those implementing it are good, it will prove to be good. A very good afternoon to one and all present here. I am Bharat Gowda BR from first year LLB of KLE Societies Law College, Bangalore. On behalf of KLE Societies Law College, Bangalore, I welcome you to this webinar on judicial independence and accountability by Mr. Shivraj Huchanawar sir. I would now like to call up my friend Raksha of First Year LLB to welcome and introduce our honorable guest speaker, Mr. Shivraj Huchanawar sir. Raksha, over to you.
Thank you, Bharat Gowda. That was indeed a great start. A constitution is not a parchment of paper. It is a way of life and has to be lived up to, said Justice Hansraj Khanna once. A very good afternoon to one and all present here. I'm Raksha from First Year LLB, and I'd like to offer my sincere thanks to our resource person, Mr. Shivraj Huchanawar sir, gracious enough to acknowledge our invitation to address this special lecture. KLE Society's Law College, Bengaluru takes great pride in welcoming Huchanawar sir. I'd like to briefly place before you all Mr. Shivraj Huchanawar sir's profile. Mr. Shivraj is a doctoral research and a part-time tutor at Durham Law School. He was awarded a Durham Law School studentship for his doctoral research. Sir is a member of Law and Global Justice Research Cluster at Durham Law School. Mr. Shivraj holds LLM in Constitutional Law with first rank from Karnataka State Law University. He is also the recipient of the Nani Palkiwala Memorial Gold Medal for scoring the highest marks in LLM exam. Sir has over 3 years of teaching experience. His teaching interests are in the areas of contract law, tort law, and UK constitutional law. Mr. Shivraj has worked at the National Judicial Academy India, a think tank on the issues concerning the judiciary, and has delivered more than 25 training programs to judges in India, Sri Lanka, and Bangladesh. His current research on prevention, control, and abatement of judicial corruption and misconduct, a comparative study of regulatory mechanisms in India and the United Kingdom, revisits the conceptual framework that underpins the judicial conduct enforcement in India and the UK. Sir has numerous publications too under his name. On behalf of everyone at KLE Society's Law College, Bengaluru, I heartily welcome you to this session today, sir. We indeed feel honored to have you with us today. I also extend a hearty welcome to the audience watching us live over Zoom as well as our YouTube channel. Thank you. Over to you, Bharat Gowda.
Thank you, Raksha, for the wonderful introduction of our guest. We are impressed and inspired to learn from our guest speaker profile. Before the session begins, let me remind you all that all of you here are free to drop in questions in the chat box. We would have a question and answer session towards the end of the webinar. Now let's listen to our much awaited speaker. Over to you, Mr. Shivraj sir.
Thank you, Bharat and Raksha. Thank you so much for a generous introduction. I hope I'm audible and you can see my slides as well.
Yes,
if there are any technical difficulties or glitches, please let me know. We can pause and we can resume the session as it needs to be done. Okay, thank you so much. Thank you so much for having me today. What I'm going to do is I'll be discussing judicial independence as well as accountability, starting with a brief introduction to what judicial independence as well as accountability as I understand it. A couple of things have to be said earlier. Number one, what we are going to do today is not comprehensive audit of judicial independence and accountability, because these two concepts are multifaceted. We have to spend a lot of time in understanding what judicial independence, accountability, how they sit in constitutional framework of India and all that. But we are going to limit our discussion to three very important aspects of judicial independence as well as accountability. Those aspects are internal judicial independence, institutional judicial independence, and individual judicial independence. Likewise, what I'm trying to do is I will be highlighting the same aspects of judicial accountability as well. So when I say a same aspect, once again, I'm going to talk about judicial independence as well as accountability in terms of institutional, internal, as well as individual. There are two reasons why I'm doing it, because this is the easiest way to go forward, and this is the best way I know to understand judicial independence and accountability. I'm sure my listeners as well as viewers will find it easier to understand this way. So that's the first conceptual analysis part of the presentation. The second thing would be, obviously we are law students, we have to discuss a couple of important as well as landmark decisions on the subject. So I'm going to discuss a couple of cases, not many. However, my emphasis will be on judges case 2 as well as NJSC judgment. This is because judicial primacy has to be critically audited to see how judicial accountability paradigm sits within the constitutional framework of India, as well as whether we have adequate protection to individual as well as internal judicial independence in the country has to be seen. For that, we need to critically audit both the judgments. That's the reason why I'm going to primarily emphasize on those two judgments. You will be very interesting, especially law students will be very interested to know about subordinate courts, subordinate judges, whether they are independent, whether they are accountable, to what extent we could say that there is adequate judicial accountability of higher judiciary as well as subordinate judiciary. These are interesting questions I am going to deal with today. So let us start with judicial independence. What is judicial independence in the first place? You see, as I said, it is a multifaceted concept. Fine, it has a varied conception in civil law jurisdiction. It has got different meaning in parliamentary system or in a written constitution paradigm. This term has got a varied conception. So what is judicial independence? Do you think Indian constitution provides for adequate safeguards to judicial independence? That's the follow-up question that follows. But then the question is, what is judicial independence? As I understand judicial independence.
Apologies to intervene. Could you kindly share the PPT over full screen, sir?
Okay.
Thank you.
I'm sorry.
So the icon is in the bottom right.
Yeah.
Yes,
Okay.
thank you.
Can you see now?
Yes, sir. Yes.
Okay. Sorry, guys. I was discussing about the meaning of judicial independence. So the question is, what is the meaning of judicial independence? For whom, from whom, and for whom, for what judges should be independent. First thing is, as I understand it, the judicial independence is a state of mind, is a competence of a judge. When I say judicial independence is a competence of a judge, it means whether judge is in a position to sort of decide or make determination based on law, whether he is able to uphold the values that are enshrined in the constitution, whether he is in a position to avoid his own narrow understanding of life, whether he is able to sort of avert his personal biases. So at the individual level, judicial independence really means competence of a judge. Law students should know that judicial independence does not necessarily restrict itself to judges. When we talk about judicial independence, it also includes independence of court staff. In other words, court staff should also treat litigants with equality. They have to exercise due diligence. They have to sort of show propriety, probity, honesty, openness, transparency. So all these concepts that underpin good governance are embedded in this particular judicial concept called judicial independence. So judicial independence at personal level means our judges should be independent of their personal views. They should be able to uphold the constitutional values. They should be able to determine cases before them in accordance with law. they should be able to uphold the oath they take. That's judges part. Likewise, the court staff, advocates, prosecutors, and all other judicial personnel should be competent enough to do their job independent of external influences or personal biases. That's how this concept is sort of wider in its scope. So the best way to understand judicial independence is, number one, individual level. At the individual level, I just outlined what judicial independence means, and then internal. Just like any other institution, government or private, judiciary has also is an institution. It has got a huge machinery. For example, High Court of Uttar Pradesh will have employees of around 2,500 employees. So it is a huge machinery. There will be internal arrangements. There will be intra-branch communications. There will be frameworks that regulate not only the functioning of the judges, but also the court officials. So within the judicial framework, we need to answer the question whether the frameworks that or the internal arrangements that we have in place sufficiently safeguard decisional autonomy of a judge. Likewise, whether the internal arrangements that we have in place sufficiently safeguard the autonomy of court personnel. That internal dynamics are also relevant to understand, to make determination whether judiciary really independent or not. And then comes to very popular aspect of judicial independence, institutional independence. So when as a constitutional student, when we read our constitution, we gather so many provisions with respect to institutional safeguards. Judiciary should be protected from external. Hello, am I clear?
Yes, sir, you are.
Yeah. So there are various provisions in the constitution that outlines or provides for. I hear some noises, so that's the reason why I'm sort of disturbed. So institutional independence sort of protects the interest of the institution. As a judiciary, there should be separation of powers. Judiciary should be separate from the executive legislative body. Likewise, we also ensure that judiciary gets enough support from the executive branch, it gets enough support from the legislative branch. They are able to do justice, they are able to uphold the visions of the constitution in an independent way. That's overarching theme of the constitution. So judicial independence has to be understood from individual perspective. There are some disturbances, I'm sorry.
So apologies, you may proceed. I'll look into it.
Yeah. Likewise, I am going to sort of outline judicial accountability in the same way. When we say whether our judges are accountable, whether our judiciary is accountable, we have to see once again judicial accountability in this way. Number one, whether our judges are accountable at the individual level, whether our judges are the judiciary internally has enough adequate mechanism to ensure that whatever goes within the judiciary or whatever arrangement that we have, ensure that everything goes well and fine in accordance with law, of course. And now institutional accountability is very important. Inherently, we can certainly argue that the court processes themselves ensure a certain degree of accountability. For example, hearing case in public, you see, listening to the advocates from both parties is some form of an accountability. So judge is going there in the courtroom, putting a show that involves so many actors. So every judicial duty holder, or should I say the stakeholder, participates, and participation, each one of them should be in accordance with the procedure. So this is a basic security we have, and it is a sort of a form of judicial accountability. Likewise, speaking orders, they have to reason it out. Judges have to write the judgment, and they have to reason out their judgment. So there is accountability inherent in the procedures and processes that we have. But these, of course, these procedures and processes are not sufficient. That's the reason why we talk about additional accountability measures. Now the question is, even though we can understand this judicial accountability concept in three levels, the question is, do we have adequate accountability measures in India? That's very important and burning question that we will look into. But I am going to make certain suppositions before I proceed to the next part of the presentation. Supposition is that, number one, my students and whoever on this platform now listening to me have good understanding of what constitutional provisions are with respect to judicial independence. You need to have basic understanding of what happened in Constituent Assembly, what were the considerations that were influenced the constitution makers, why partial separation of power was chosen over strict separation of power. There was a consultative process that was sort of outlined and embedded in the constitution by the constitutional makers. What are the reasons for having that consultative process? When I mean consultative process, means when you read constitutional provisions, it is very clear decisions pertaining to appointment, transfer, deployment, confirmation of high court as well as Supreme Court judges should be made on consultative basis. So state government, union government, state judiciary, union judiciary have to take part in a consultative way. In a sense, everybody get to say what their views are on particular appointment or transfer decision, and the President of India thought to be will be acting like an umpire if there is a disagreement. So this was the basic framework, this was a basic understanding we get when we read constitutional provisions in the first place. Of course, this consultative process is changed because of the judicial pronouncement. I will go to or discuss those changes very quickly from now. But then you need to have what was the initial framework, why this initial framework was proposed, accepted by the constitutional framers. That has to be seen. So another thing I have to bring it to the notice of my students here is that even though there were executive primacy, when I say executive primacy here, when you read constitution, you gather that formal as well as final determination or decision with respect to appointment, transfer, could be made by the executive. So when I say executive primacy, means the final word on this matters lied with the executive branch. So there was executive primacy inherent, embodied in the constitution. But there was a strong constitutional convention that underpinned the practices of first 2 decades of the independence. So what I mean here, up to 1970, at least leading up to emergency, in India, even though executive had final word, they acted in accordance with the recommendation of the Chief Justice. So there was a constitutional convention. That convention said executive branch should comply with the recommendations and views of the Chief Justice, and more or less this practice was continued for first 2 decades after independence. So my students need to have this basic understanding. This is what was the framework before Judges Case 2 came in and established judicial primacy. So I'm going to make an assumption here that my students understand, have good grasp over Constituent Assembly debates. They know constitutional provisions very well. They know rationale that underpins partial separation of powers. They know what executive primacy meant. Also, very importantly, a constitutional convention, its existence and its compliance. So with these so many basic assumptions, I am going to move to one very important case law. I'm not going to discuss this case law extensio because we don't have time to do that, but I'm sort of highlight this case because this is the beginning of sort of challenging executive primacy in Union of India versus Sankal Chand Seth case. I am sure all of you know the facts of this case. This is very simple case. Factual matrix are very simple. In this case, a High Court judge was transferred from Gujarat to Andhra Pradesh. He took charge in the Andhra Pradesh High Court, but he challenged the transfer order, saying that this order was passed without my consent, and Chief Justice of India was also not effectively consulted. Very important questions were raised pertaining to Article 217 as well as the 222 of the Constitution. Interestingly enough, in this case, court come to a conclusion that consent of a High Court judge with respect to transfer is not necessary. Another very important thing we have to understand in this case in Sankal Chand is that consultation with the Chief Justice of India is mandatory, but his views, recommendations are not binding on the president, on the executive branch. So in other words, they upheld executive primacy in matters of appointment as well as transfer. That's the underlying understanding of Sankal Chand. Now coming to another very important case, SP Gupta versus Union of India. First judge's case, we call it as. Before that, we had another very important Subhash Kumar case versus Union of India. I would argue Subhash Kumar was the starting point where they referred the matter, that is SP Gupta versus later came to be known as SP Gupta versus Union of India, to larger bench of 9 judges. So because we have limited time, I am just skimming through important case law so that I come to very important discussions today, that is Judges 2 as well as NJC judgment. So again, this is in terms of facts, this is a little complicated case law, but in itself, this is a case that involved 8 important issues. 8 petitions were clubbed. There were 5 very important issues. I will just narrate or state that this case involved issues relating to transfer, appointment of additional High Court judges, and there was also very important issue pertaining to transfer of Chief Justice of Madras High Court. So once again, to oversimplify things, SP Gupta versus Union of India case concerned with transfer as well as appointment. So what was the decision? I am sure all of you know this. Once again, court upheld executive primacy. The court come to conclusion that consultation is mandatory but not binding on the executive branch, that is the president. Interesting, once again, is to see that consent was not considered to be necessary, even though there was strong dissenting judgment from Justice Chandrachud and another judge. One thing I would highlight here is that court held judicial appointment and transfer policy introduced by government, which was challenged in this case, cannot be ruled unconstitutional because it is subject matter of executive discretion. It falls within the executive domain. So clearly, in Sankal Chand as well as in first judge's case, judiciary, that is the Supreme Court, interpreted the Constitution which is consistent with the literal interpretation that could be attributed to constitutional provision. So what is underlying understanding of these 2 cases is very clear. Supreme Court adopted interpretation method which stayed to be very close to the text of the Constitution. So there is no judicial creativity, in short. SP Gupta as a student of constitutional law is very important for another very important reason. That is, here court claimed that just like business of government, just like any other department, judiciary should be transparent, open, and accountable with respect to appointment as well as transfer. Court clearly recognized in this case that appointment as well as transfer procedures are somewhat mysterious. Nobody knows anything about them. Only 4 or 5 people, that is Chief Justice of India, Chief Justice of High Court, Union government, state government, participate in this mysterious activity, and we know nothing about it. So they said openness, transparency, and accountability are very important values we need to adhere to, comply with, even with respect to judicial independence as well as accountability. So SP Gupta, in that sense, very important. I will come to this judgment, this understanding of openness, transparency, and accountability by courts in later case as well. But let us move to another very important case law, that is Judges Case 2. Yeah, I would call it as the new beginning, because as I already made it clear, this is the case where we see judicial primacy taking complete grip over appointment as well as transfer procedures in this country. Irony is that when I said in Subhash Kumar, the three judge bench referred this case to higher bench on two very important reasons. The referral was very limited with respect to what is the position of Chief Justice of India with respect to primacy, and another was not very substantial question of law, whether fixation of strength of high courts is justiciable. So that is not very relevant for our discussion today, though very important question. So the referral was very limited in that sense. But then here you see judicial creativity at its best. Court, especially Justice Verma, come up with 14 important conclusions. I'm going to sum up a couple of them. Number one, they said with respect to transfer of High Court judges, consent is not necessary. Of course, it is consistent with the judgment that we looked into. They said another very interesting thing, I will be critically looking at this determination later on. They said since the transfer orders will be made by the Chief Justice of India, transfers cannot be deemed to be punitive. This is very important reasoning. This is flawed reasoning, I would argue, but then that is what the outcome of this case is. And another interesting thing, you all know it, I assume so. A court interestingly came with this particular sentence: the relevant provisions of the Constitution, including the constitutional scheme, must now be construed, understood, implemented in the manner indicated herein by us. It means to say that whatever Article 217, 222, and other relevant articles of the Constitution say, appointment, transfer, confirmations will be made as outlined in the judgment. So we are proposing new procedure of appointment as well as transfer. So in that sense, we are amending the Constitution. So you have to construe, understand, implement Constitution in a different way as envisaged by the constitutional maker. So this is a sort of rewriting of the constitutional provisions in a limited sense. So as I said, Judges 2 was a new beginning, but the question is, was it really new beginning? I'm asking this question, and this is the important part of my presentation. This is what I wanted to highlight. Number one, yes, there were reasons why judicial primacy was felt necessary. Okay, there was a distress, there was instances of abuse of executive power by the executive branch. We all agree with that. To certain extent, there are justification for judicial primacy, but the question really is, we adhere to partial separation of powers. What is the underlying principle of partial separation of power? Is checks and balances. Now the question is, if something some judges think that the determination or a decision made by the collegium is mala fide, it was impacted by corrupt motives, then what is the remedy available to that person? So I'm talking about transparency, accountability, checks and balances with respect to collegium that Judges 2 case created. Another important thing is that high courts in India are autonomous constitutional institutions. you are centralizing powers, especially by limiting the powers of the executive branch as well as the state government to such a certain extent of high courts. There is a clear fusion of powers in the collegium of and chief justice. The interesting question as a law student we need to ask, wait a minute, we have adhered to partial separation of powers. Now judges, by writing these particular decisions, they are sort of concentrating powers in themselves, uh, interpreting it to be necessary to protect judicial independence. So there is a clear fusion of powers in chief justice and the collegium. What is the rationale? Whether judicial independence really needs such a fusion of powers, that question we need to ask. As I said, this judgment clearly weakens the role of executive branch, not of union, not only of union judiciary, but also of state judiciary. The question once again had to be asked: is it the federalism we envisaged in the Constitution? That question need to be asked. And another very interesting thing about this judgment is that a court made it very clear, Justice Verma made it very clear, upon reiteration, the recommendation of the Chief Justice, that is the collegium, should be accepted by the executive branch. Okay, so there are very limited exceptions, exceptional situation where they said we are not going to go ahead with the appointment even if you are recommending for the second time. So in that sense, they are upholding, they upheld it, the determinative character or determinative nature of sort of view of this Chief Justice or the collegium. So why this primacy, why this determinativeness, why the decision views of Chief Justice of India should be considered as conclusive binding on the executive branch, where the Constitution clearly had different plans for the country? That has to be asked, that has to be answered. So another interesting thing from the perspective of judicial accountability is there is no emphasis on judicial accountability whatsoever. Okay, fine, you have a different scheme of appointment, but what about accountability? Where is the accountability? How, if high court judge or a Supreme Court judge conducts himself in a bad way, apart from impeachment, what is the mechanism that we have to hold such person accountable? They don't talk about accountability. So there is imbalance between independence as well as accountability. That has to be clearly seen by students, whether you agree with the decision or not. Likewise, where is the openness? Where is the transparency? That's the reason why I emphasize SP Gupta, saying that in that case, court held openness, transparency, accountability are necessary values in any democracy. How about collegium? Why it is still secretive? Why it operates in opacity as well as obscurity? That has to be questioned. And another very interesting thing, this is the implication. After this judgment, the confrontation between executive as well as judiciary has been sort of a norm. Okay, as I said in the beginning, for the first 2 decades, we had a very good arrangement, satisfactory arrangement, if not very good. But then after this judgment, we see a clear distrust. There is distrust. There is no consultation, because they think, executive think judiciary is abusing its power, and there are good reasons why we should to see executive branch with suspicion as well. So there is a distrust, and part of it could be attributed to this judgment, because there was uneven bargaining power. When you say whatever I say, you have to accept it, there is no real consultation possible. There is a disequilibrium. There is a sort of unequal bargaining positions of the consultative parties. So that is very sort of antagonistic to consultative process itself. That has to be borne in mind by the students. Another very interesting point I'm going to make, and this is the most important argument I'm going to make, is that this judgment laid out no emphasis whatsoever on individual independence. When you say that when CJI makes the determination with respect to appointment transfer, you cannot challenge it in any court of law. The question is why? You criticize, we all criticize Sankal Chand, the case relating to transfer, because we thought You see, there was a scope for executive misuse, and judiciary did nothing to prevent it. But the question here is, what now when judiciary has a primacy? Why they are not allowing judges to challenge the decision made by the collegium or by the chief justice? What is the rationale behind it? Where is the accountability? So these questions, these unnerving questions has to be asked to find an answer to. Of course, I'm not going to answer, or I'm in a position to answer all the questions, but as a constitutional law student, you need to bear in mind these questions. Another very important point, this decision, I argue, undermines the autonomy of high courts. As you know, most of the chief justice, almost all of the chief justices are outside from that particular state. They keep the one eye on the Supreme Court, so they want to get elevated. But the question is, the elevation, the transfer, the confirmation, every important decision with respect to judiciary is made by this collegium. So as a chief justice, I will not be willing to sort of unnerve my bosses, so that hello, sorry guys. So what is the security for internal independence that I was emphasizing about? As I said, high courts are constitutionally autonomous institutions. There is no administrative hierarchy. I want to tell one important thing to the students. We have one judiciary on judicial side. On administrative side, we have judiciaries, union judiciary as well as state judiciary. This distinction is clearly maintained by the text of the Constitution itself. Okay, that's the reason why all constitutional teachers in the country tell you that high courts are autonomous. They are co-equal branch within the judiciary. They are subordinate to Supreme Court only on judicial side. But when important decisions concerning judiciary, high courts are made by the Supreme Court, then how would you say that there is a greater autonomy? Isn't it? So I would argue this decision diminishes significantly the autonomy of high courts. And another interesting point I would make with respect to this judgment is it lacks sound factual basis. Why I say so? Because of this. Between 1983 and 1993, in this 10 years, 547 appointments were made. You will be pleased to know only in 7 cases, the views or recommendation of Chief Justice of India was undermined, discarded. What I mean to tell you here is that even when we thought executive branch was abusing the power, in fact, they are sort of respecting the views of Chief Justice of India. This is the case when they had executive primacy. So what happens after 1993? We all know a collegium system did not live up to the expectation that it created in the first place. So what I mean to tell you is that there are questionable appointments, transfers, confirmations, whatnot. So one would argue that there is no factual basis. You are acting on suspicion. You don't trust the executive branch. You fear the executive branch. You still living in the fear of 1975. But in reality, there is no sound factual basis for the outcome or the determination. I'm not going to discuss a special reference of 1999, but I would say this was a missed opportunity, because by 1999, it was very clear that collegium is going to fail. It has failed. It has created tough controversies in this 5 to 6 years time. So there was opportunity to reconsider. Supreme Court missed that opportunity in this case. Coming to another very important aspect of my my presentation. I'm sorry I'm running out of time, but I'll skim through. I think I have a couple of important points to make with respect to the latest judge's case, the NJSC case. Okay. So a couple of points. One interesting thing here, when I read this judgment, I always laugh about this reasoning. I think it is flawed. I will tell you why, and I'm talking about judicial primacy, of course. They said judicial primacy is indispensable. Judicial primacy is essential for upholding, strengthening judicial independence. I would respectfully disagree with this kind of reasoning, because what can we say that between the period of 1950 to 1970, Indian judiciary was not independent because there was executive primacy? Can we say that because in UK, mostly the executive branch as well as judicial branch sort of act in partnership to make important decision with respect to appointment as well as deployment of judicial personnel? Can you say that UK judiciary is not independent? So the question is why we should consider judicial primacy as an important component, indispensable component of judicial independence. We all agree that judicial independence is a basic structure, but then whether it is necessary to protect judicial independence that our judges should appoint judges, I doubt that understanding as well as rational here. So that's the reason why I don't think, personally, I don't think judicial primacy or executive primacy for that matter are not essential characteristics or basic foundational components of judicial independence, even though judicial independence is a basic structure. So there is a doctrinal incoherence, unsound reasoning. And of course, there is a trust. When you read this 1,000-page judgment, you will see that uh, there are a lot of jugglery of words. They try to hide what they wanted to tell, but it is very clear. There is clear distrust. There is clear fear. There is perception of incompetence of executive branch. There is inherent assumption that judiciary does these things better than the executive. Okay, that is very clear when you read the judgment. And another very important thing I want to highlight about this judgment is this. This is highlighted by Justice Chelmsford himself. So this is not my interpretation of things. The conclusion that Parliament lacks authority to annul primacy of the CJI. This is very, very important. You are not allowing Parliament to define how Chief Justice should exercise his discretion. You are saying that Chief Justice of India and the Collegium has to make all important decisions relating to judiciary. The fact that you are not allowing Parliament to make those changes, which inherently falls within the ambit of legislative body to make laws. Even the Constitution tells that the Parliament has to make provisions with respect to judicial administration. There is a clear inherent legislative competence on subject matters concerning Indian judiciary lies with the Parliament. But despite that, you are saying that no, you cannot alter, in some way modify or take away or abridge some of the powers of the Chief Justice of India. This is absurd, I would argue. So Justice Chelmsford does this very effectively. So there is sort of misunderstanding of judicial independence. They think primacy is essential. I would argue primacy is not essential, whether it is of executive or of judiciary. Consultative process was best process. Partnership is good thing. This is my personal views, of course. I'm not here to sort of propagate my personal views. I'm here to provoke students to have their own viewpoints on these important questions of involving constitution as well as judicial independence as well as accountability. So the question is, where is the emphasis on judicial accountability? Quite frankly, I would argue there is no adequate emphasis on judicial accountability. That's the reason we are, in terms of accountability, a backward a constitutional state. Sorry to say that, but that's the reality. Our judges, especially High Court as well as Supreme Court judges, are not held adequately accountable. It is clear as the day. It is written on the wall. So there is no second thought about it. I have just explained you. So I will move on. This is underscored by, not by me, Justice Krishna Iyer said that Justice Verma himself admitted after retiring, being Chief Justice of India, that judges today are not answerable to anyone. Justice Ambedkar, sorry for that. Ambedkar very clearly said, we are not going to confer veto power to the Chief Justice. He thought it is a dangerous proposition. Now, as I promised you, I'm going to talk about subordinate judiciary briefly. I will take 10 minutes to sort of emphasize the framework that enables judicial independence as well as judicial accountability with respect to subordinate courts in India. So the first thing is, when you read chapter 6 of chapter 6 of part 6 of the Constitution, it is very clear that high courts in India have administrative as well as judicial superintendents and power to control subordinate courts. Very clear. So what I mean to tell you is very simple. The constitutional framers thought that it is important we make high courts as a custodian of subordinate judiciary to protect, to uphold, to strengthen judicial independence. They thought the arrangement that we had at that time, and rightly so, was not inspiring confidence. There was no strict separation of powers between administrative branch as well as judicial branch. So they thought separation of judiciary from executive, that is administrative branch, is very important, necessary, and that the subordinate judiciary should be monitored, mentored, sort of inspired by the High Court. That's the reason why administrative supervision or superintendent, judicial supervision or superintendence is solely conferred upon High Courts with a view to protect judicial independence. So appointment, posting, promotion, transfer, confirmation, fixation of seniority, suspension, disciplinary action, so on and so forth, with respect to judges, that is subordinate court judges, are made solely, exclusively by, I would argue, exclusively by the High Court, and then later on conferred by the state government in the name of governor. That is the constitutional provisions and the position if you read chapter 6. And these are the decisions. I'm not going to go into details of any one of them, but if you are interested, go have a look at those decisions as well. So now I'm going to emphasize very briefly about, are there adequate checks to prevent abuse of high court judges' power of superintendence and control? This, I think, very important, pertinent questions, which is not adequately inquired by academicians, judges themselves, of course, by media, quite frankly. So the question is, I am a magistrate. Imagine that I am a magistrate to whom I am accountable. I am accountable to my next senior judge, that is Chief Judicial Magistrate. I am accountable to a district judge in many cases. I am accountable to administrative judge. Who is administrative judge? Administrative judge is the High Court judge who is responsible for the judicial administration in that particular district. So every judge in that district in one or other form is accountable to administrative judge. The accountability does not stop there. In fact, it gets compounded because every judge in one or other way is accountable to committees of high courts. So every high court will have 20 to 25. In big high courts, there will be 50 or 60 committees. So these committees also enforce some degree of accountability over every judge in a jurisdiction. That is a reality. And on top of these committees, we have Chief Justice, and on top of this, we have full court as a accountability holder. So my argument is that there are too many account holders. There are too many seniors, supervisors supervising this poor magistrate or a Chief Judicial Magistrate or a sub judge. So there is too much accountability. To quote it in a different language, there is accountability overload. So therefore, I would say another interesting thing I want to highlight is that imagine that you are removed from judgeship. You are a civil judge. You are removed from the judgeship. Now you think that there was some irregularities with respect to making that determination by the government, or that is the High Court. So you want to challenge it. Where you will go now? Service jurisprudence tells us that every employee on administrative side have appeal. So if you are a government appeal, obviously there is a tribunal, you go there. If not, then you will go to judiciary on judicial side. So the question here is, you are a judge, where you will go now? There is no appeal. There is no first appeal on administrative side. The judge has to go to high courts, the same high courts which made that determination, the same full court made the determination to remove you. Now you have to go before a couple of judges sitting there as a division bench, and they will hear you. Those judges may be very objective, they may be impartial, but it such kind of arrangement sort of is an unhealthy interaction of administrative as well as judicial powers. So what I'm trying to tell you is that we need to have a robust accountability mechanism. We need to have a normative structures that fairly, independently, autonomously administer judicial accountability and appear to be so. I'm not sort of alleging that our high courts are biased. I'm not saying that, because I have no evidence to say that, even though there are plenty of case laws which suggest so, but I'm not reaching that conclusion yet. But what I'm trying to tell you is that we lack robust accountability mechanism. That's a takeaway message for my students present here. So again, likewise, performance evaluation, they call it as ACR, is a flawed at many levels. Inspection, surprise inspection, stoke fear in judicial officers, too many administrative responsibilities with sacrificial accountability. If there is something some misadministration, malfeasance happens in your court, you are accountable, that is reflected in your ACR, so on and so forth. So too many accountable account holder, patronage, favoritism, casteism, institutional discrimination, less said is better. So there is these challenges as well. To borrow Upendra Bakshi here, junior judges in India are treated with arbitrary, feudal, and despotic tendencies. This is quite right statement to make. So this is one of the principal judge who shared his views on administrative arrangement and how high courts treat them. He said, High Court is not all objective in dealing with district judiciary. They are being punished for bona fide judicial orders. District judiciary works in environment of fear, of bar, High Court, unwholesome for the system. So not just anecdotal evidence that I'm relying on. I'm talking to judges on this as a research student. So I would strongly argue that there is lack of robust accountability mechanism. There is accountability overload. Our lower court judges are overburdened with administrative work. So there is no right balance between independence as well as accountability. I quite rightly argue that there is too much of accountability, too little autonomy for the lower court judges. This is my argument, of course. You can disagree, certainly. So I'll just look at the time now. Okay, 2 minutes. I'm so sorry. So as a researcher, I do research in the areas concerning supervision power and controlling power of the High Court. I talk to judges, I talk to lawyers, I talk to academicians who know the system better. So I conducted an empirical research of about 120 participants, including High Court judges, subordinate judges, lawyers, as well as academics. The findings, I'm not putting number here because I have to review my findings. Percentages as well as numbers I'm not highlighting here, but overall conclusion is that there is too much accountability. Vigilance mechanism that I'm studying is not very effective. Judicial corruption, it is not very effective to handle. A vigilance mechanism don't do their job well. As even with respect to judicial misconduct, there is no effective mechanism to enforce. There is misuse of accountability regimes that we have in place. False and vexed complaints are made against charges. It is reality. So there is accountability gap that exists here in India with respect to subordinate judiciary. So the conclusion that I'm sort of drawing here is very simple and clear. Certainly, judicial independence is basic structure, but the question is of primacy. It doesn't matter really who holds the primacy unless there is a right balance, unless there is cooperation and partnership. It is never going to work. And the second important conclusion I'm going to make is that for judicial independence to flourish, we need to have accountability mechanisms, and they should be robust accountability mechanisms. They should not be just for the namesake. So another important conclusion, by now you should it should be very clear to you. Just like institutional independence, internal as well as individual independence are very important because if you emphasize adequately on internal as well as individual independence, you automatically think about accountability and mechanism to enforce that accountability. So there is no real contradiction between independence and accountability. If you rightly understand the concept, if you have a very good understanding at the conceptual level, what is the purpose of judicial independence, why it should be there, why it legitimizes public confidence in the system, what we should do to enhance legitimacy, to enhance public confidence in the judiciary. If you ask this right questions, then obviously accountability mechanisms as a value, as a mechanism, as a system, you think about it, you set those things right, which rightly now are not working properly. So conclusions, these are my conclusions. A personal request, I'm so sorry. I'm sure all my students join me today have in their contacts many judges, advocates, and legal academics. Please do share this link. Let judges, advocates, and legal academics participate in this particular survey. I think this is very important survey with respect to subordinate judiciary. So help me with this. I'll be looking forward to sort of share this my finding with you all in coming days. Thank you so very much for listening to me. If there are certain technical glitches, for that I'm extremely sorry. Thank you so much for this opportunity, guys.
Thank you, sir. Thank you. Sir has indeed planted the seed of knowledge that will grow inside our minds forever. Thank you very much, sir. We would now have the question and answer session. Over to my friend Sagar Naidu of First LLB to kindly relay the questions to the speaker. Over to you, Sagar.
Thank you, Bharat. I'm Sagar Naidu from first year LLB. We'll now take up questions from the chat box. First question being asked by Harsha is unchecked judicial independence and huge pendency of cases in the courts an impetuous factor to lose faith in judiciary, which has also paved the way for legislature to interfere in judicial functions?
Could you please repeat the question?
Is judicial independence and huge pendency of cases in the courts an impetuous factor to lose faith in judiciary, which has also paved the way for legislature to interfere in judicial functions?
Yeah, I will answer this question in two parts. Number one, as a legal academic who knows judiciary a bit more than rest of the members of the academy, I should make this very clear. Public confidence in judiciary sometimes is stoked by media reports. It is largely driven by narratives. So whether in country like India, what our judges really do on day-to-day basis that informs public views is once again question which we have to, as an academician, take seriously as a research topic. So I would argue there is no correlation in reality between what our judges do and whether it reflects in the public opinion. But second thing is, the pendency is a serious problem, and certainly there is a correlation between pendency and perception of judiciary being efficient, impartial, effective, and to a certain extent independent. But because there is a delay, I wouldn't think that public mind it as a question involving judicial independence, isn't it? Why it is so? And as a law student, we should also not make this mistake, because a judge is one of the important component in the judicial system. He is not the only component. He cannot control all the stakeholders, duty holders. You see, he has to cooperate with them. So we cannot blame one person or the High Court for that matter. As a society, we need to be responsible. We need to evolve. We need to learn how to cooperate. Our lawyers should cooperate. Prosecution should do their job. The public administration should support. The government should support. The academy has to come up with criticism as well as constructive suggestions. So this is a grand project involving all the stakeholders within the judiciary. So don't blame. We as an academic, as a students, have very important role to play. We need to ask right questions to right persons. We have to come up with some suggestions. That should be the mentality. I will take up the next question. I hope I answered the question.
Yes, sir. Thank you, sir. Now we'll move on to the next question. Question is from Pramod. What if a judge's behavior is not up to the acceptable standards as mentioned in Restatement of Values of Judicial Life, or he is reported with allegations regarding his discharge of judicial functions? What are the in-house laws that are enforced upon the judge?
Yeah, again, a very important question, but three-part question. Answer will be in three parts. Number one, there is, unfortunately, this is a statement of fact. Unfortunately, when we talk about this judicial values, this is too abstract. The 16 values that we have, they are inadequate. They are not applicable to district judiciary. There is no mechanism to enforce the 1997 resolution that is approved by the Supreme Court. So what I'm trying to tell you is very simple and clear. The conduct code or restatement that you are talking about, it's not really binding. And even if it is binding, the question is, it is too abstract. How can you make it, implement it? There is lack of comprehensive code of conduct. That's the first thing. So judicial restatement of judicial value of 1997 in itself is a flawed, weak, lacks normativity. So first thing, as an academic, you have to read international developments on the topic. We have comprehensive codes on how judges should be conducted themselves and how they should be and how their conduct should be enforced. And number two, this is very important. As I said, judicial independence really means independence of courts. So there should be code for court officials as well, isn't it? There should be code for advocates, and that should be enforced. The mechanism that we have, unfortunately, with respect to lawyers, we all know it, how it works. It is ineffective. So unless you have a robust bar, how can you imagine about robust judiciary as well as robust bench, isn't it? That's the reason why if you are very serious about enforcing judicial conduct, you should be serious about defining what judicial misconduct looks like. You should be serious about making a distinction between judicial corruption as well as misconduct. You should actively pursue corruption situations within the judiciary. Now they are brushed under the carpet. That is not the best solution. So the first solution is have right mentality, identify the problem, have awareness of the problem. Second thing is come up with a comprehensive judicial conduct code that is applicable not just judges of Supreme Court, it should be applicable to judges as well as court personnel. And third, very important, mechanisms. Mechanisms are very important. You lecture judges about how they should conduct, but if there is no mechanism to enforce those values that you are talking about, it doesn't make sense, isn't it? And fourth important answer, my dear friend, is this: people should know that there are values and there are mechanisms to enforce those values. If you search for register vigilance, you will not find a link on any websites of the High Court. So why, from whom you are hiding, isn't it? You should let the public that there is a complaint mechanism, isn't it? And what is the procedure this register vigilance mechanism follows? Nobody knows. Where are the rules? Why they don't respond to RTIs? See, transparency start within. You should be accountable to yourself. You should be transparent with yourself. That's the lacking part of it. So the important take-home message is this: we lack intent. And that's the reason why all these symptoms that you have identified are coming up before you. So to fix the problem, you need to have right intent, right mindset, and that will solve the problems that we have. Next question, please.
Yes, thank you, sir. We'll move on to the next question. Next question is from Harsh again. What is your take on tribunalization of justice, giving scope for experts in strategic fields? That is a National Green Tribunal. Will it hamper the power of Supreme Court in our country?
Number one thing, there is inherent justification or rationale for tribunalization, because life is complex and it is getting complex every day. Participation of experts, not just in the form of tribunals, even on benches, we need to have experts. There is no denial of that. So tribunals are essential. Let me restate it. Tribunals in any country in this complex world are essential because two things the tribunal does very effectively. If you organize them effectively, if you can make them work effectively, they can contribute in two ways. Number one, they can deal with technical aspects of adjudication very well. They know how to do, they know the subject, they know how to conduct this the cases well, they know intricacies of questions involved in a particular field, so they sort it out very quickly. And number two, very important, they don't burden they don't burden mainstream judiciary. When I say mainstream judiciary, law courts. So if you can make them work effectively, certainly they can work. But coming to the expertise, how should you define expertise? Expertise, when we talk about expertise, does it mean book knowledge or life experience? How to balance it out? I'm talking because I'm a son of a former. We had a case in tribunal, and then look at the selection of members of the tribunal, all based on political consideration. So how would you expect that tribunals will work? What is the definition of expertise? That's the question. So the problem is that we misuse tribunal, and the scheme of misuse misuse start with within from the scheme itself. The plan is flawed, and of course when you have a flawed plan, obviously execution is going to fail. That's the unfortunate part of it. But to answer your question, yes, tribunalization is essential. We have to seriously rethink how we have organized our tribunal. And coming to NJIT, of course, we all know how effective NJIT is, and it is necessary. But then, of course, if you allow appeals to come up before Supreme Court as well as High Court on every issue, every IA is challenged before the Supreme Court, then how these tribunals will work effectively? They don't work effectively. So judicial review, there is a need to realign, redefine a judicial review power concerning tribunals. That is very important. And our High Court judges as well as Supreme Court judges should not see tribunals with sort of mistrust, distrust. You cannot make assumption about incompetence. That kind of an sort of lack of confidence by the mainstream judiciary with respect to tribunal is also hurting us big time. That's the answer. I hope I answered the question. Next question, please.
Yes, sir. Next question is from Subhash, sir. I would request him to voice his question and speak up here.
Good morning, sir. Good afternoon, sir. Am I audible?
Good afternoon, sir. Good afternoon. Thank you so much.
My first question is, sir, is judiciary hypocritic?
Of course, just like Mr. Shura, judiciary is also hypocrite.
And
Straightforward question. Yeah, go ahead.
Second question is that, judge second, third, fourth judgments are prima facie void.
I will ask this question with a little bit elaboration. Number one, certainly, if you read Shirwai, I'm sure Shirwai, you read Shirwai, and that's inherent underpinning of your question. Why he's the only one I know who concluded the judgment judge's case 2 as void, isn't it? So it is void certainly on technical grounds. That didn't answer your question. Number one, the Supreme Court of India has extensive judicial review power. We have extensive so motu jurisdiction. So the question really we'll be asking ourselves is this: when a particular question of law has not arisen before the Supreme Court, can it create one for itself? And the second follow-up question is whether such judicial activism is not misuse of judicial review power, isn't it? Yeah. We, as a judges, we do a lot of social engineering, isn't it? We define, redefine.
But sir, this judgment is nothing to do with the social engineering.
Yeah.
These are the judgments which is protecting their own interest rather than the interest of a society, rather than the interest of public.
Yeah.
Because, okay, you grab the power, but at least you are not accountable. And usually appointment of judges are never made in accordance with the judges too.
Yeah.
The reasons are never recorded. Reasons are
Certainly.
never recorded.
Okay, so let me sort of push forward here. The second part of my response is this. On technical grounds, certainly we can argue that judges 2 was wide, judgment was wide, because 14 findings, most of them were beyond referral, as I noted already. Yes, it was wide. Indeed, it was wide. But then it was sort of constitutionalized. We have very important term, constitutionalizing peripheral judicial values or principles through judicial activism. So the values that as a judge, I behold to certain values. I think these values are so very important. They should be brought to the mainstream, and judicial activism is the best way forward. So when I think something is right and something is going to be right, all right, it will further the public interest. National interest. What I do is I narrate my own personal biases, principles into the judgment. So that's the reason why I emphasized the judicial independence in terms of individual component. Okay, as a judge, you should be able to identify individual proclivities, narrow-mindedness. You should not think that my idea, my ideology, my theory, even if it is not consistent with the constitution, is good, is best. This approach is dangerous, and that's the reason why we find so many flawed in the reasoning of NJAC as well as Judges 2 case. So technically, of course, it is a wide decision, but then it was constitutionalized by 1919 judgment, the reference, isn't it? That's the reason why I highlighted this was a missed opportunity for the Supreme Court 1990 decision, because we all know that Justice Verma went above the referral that was made initially by Venkatachalaya. And then the issue arose before the Supreme Court. That was an opportunity to review whether second judge's case is indeed a constitutionally binding pronouncement or not. But then what Supreme Court did, they once again missed that opportunity. They constitutionalized. So judge's case 2 was wide, but it was constitutionalized by 1999 reference case.
And last, is a judiciary, judges are free from the bar bias?
Absolutely no. You can take this answer to the bank. No.
Okay, so thanks a lot.
So this is Harsha. I have a question. Our own Supreme Court has ordered for constitution of National Tribunal Commission, whereas they have made it unconstitutional for the appointment of National Judicial Appointment, NJAC. One of the judges in NJAC case, a 5-judge constitution bench, the judgment came in 3:2. Justice Kurian Joseph has regretted for his decision after his retirement. So is it not fair? Like they have ordered for appointment of National Tribunal Commission, whereas they are opposed for appointment of NJAC. Is it fair on their part?
Let me answer this question again in 2 parts. Number one, I'll talk about NJAC judgment and regret expressed by Justice Kurian. Number one, what makes a particular judge happy? It's not that his sense that, okay, this is my decision and this holds good thus far. My decision is right decision. That is not what satisfy or bring content in a judge. What brings content in a judge is that there is a logical coherence in his reasoning. What I am trying to tell you is that all 4 judges are going to regret their judgments. because they can see themselves the incoherence they have brought into the jurisprudence. For example, I will give you, read Justice Lokur as well as Justice Keher. They talk about the practices that exist in UK, and they clearly, categorically rely on the jurisprudence that was developed through Constitutional Reform Act of 2005 of UK. I can humbly submit before you is that their understanding of CRA, how UK works in terms of appointment and transfer is completely flawed. They have not understood exactly how it works. So what I'm trying to tell you is that in UK, on face at the least, there is a partnership. Lord Chancellor is effectively consulted. Okay, there is of course judicial dominance while conducting interview, while conducting examination, assessment of candidates and all that. There is a dominance. There is active participation from the judiciary. Academics criticize that as well. They think executive branch is competent enough to make contribution even at that level. That's altogether different aspect. But then compared to what we have in India, the primacy, the determinativeness, the conclusivity that we have attributed to the views and recommendation of Chief Justice as well as Collegium is dangerous, and it has no parallels. I'm telling you this because Letmer House principle of 2004 makes it very clear. Participation of executive branch into the judicial administration should not be construed as an impediment to judicial independence. It is international standard. Right about our own Singhvi, the late Singhvi I'm talking about. In 1979, if my memory serves me right, he came up with very important document in the year 1978, the draft declaration on judicial independence. First very important document at the international level. He submitted it to the UN. See and understand what was his thoughts. He was a great jurist. Most of us don't read his contribution because he worked mainly on the international level. So there you will find how he tries to sort of articulate jurisprudence that was undercurrent in all common law countries, saying participation of executive in judicial administration is very important. And he goes on to say, merely because executive makes judicial appointment should not be construed as challenge or impediment to judicial independence. So that's the reason why I said in my presentation, we need to have a good understanding of judicial independence. Okay. And this is partly answered your question, I know. The second part is you have to understand what is your role as a judge. Are you here to do executive jobs? Appointment, whether it is a judicial or otherwise, is an executive job. It's a politico executive activity, isn't it? So judges inherently are incapable of or debarred from doing their job. I repeat, they should not do the executive job. They are entitled to do executive job only as provided by the Constitution with respect to appointment of court staff in High Court and Subordinate Court, because that is delegated to them by the Constitution. So that power of the judiciary cannot be challenged. Okay, but apart from that, if you think that you can appoint a professor in law university, that's absurd, that is flawed. That's how you I sort of goes on to say that presence of judges everywhere and every aspect of life is dangerous for the democracy, for academic critic in the country. So we need to be very careful about how we should value sort of use expertise, experience of judges in our life, because they enrich our lives. They sort of have ability to define the moral compass of the country, as of the society. So we have to take their value their service as well as their opinions, but then their participation in every walks of life and allowing them to do what they want to do is dangerous to position when it comes to appointment, whether it is of a tribunal or of a election commission or of a CBI. They have to participate as a consultative member, not a deciding authority. We have prime minister, cabinet for that, and if they err, we will decide it in the election. I'm sorry, I know that our democracy is not a perfect democracy, but it takes time. We have to allow executives to take part. That's the only way we can inculcate sense of democracy and responsibility in them. We know we are a sort of a flawed democracy because there is no political maturity of that kind to run a complex mechanism called parliamentary system of governance, but it takes time. We have to sort of facilitate, encourage, and guide the executive branch sort of contribute constructively in the activities that enriches both judiciary as well as executive. And that responsibility lies with us, the academics, as well as judges who know judicial administration certainly better than executive branch.
Okay, thank you, sir. We'll move on to the next question. Next question is being asked by Apurva Chauhan. She's quoting an instance where judges basically complete their tenure with they serve the entire period, but there are often circumstances where they are being transferred due to some political interests. And she also refers this case to Justice Muralidhar's transfer and asks you, how do you address this?
Certainly. Post-retirement pending, we call it as in academic terms. There is a professor called Professor Shubhashankar Dam, who has done wonderful research on post-retirement pending. He calls it as a corruption, really, but to sort of use his post-retirement pending phraseology here, certainly it is problematic. There is as a researcher, I should make it very clear that there is a strong correlation between the offerings that judges get after retirement has a strong correlation with what they do in the first early or the sort of last year of their work. This is proved. There is research available thanks to that professor that I named. So there is a strong correlation that is problematic, that challenges not only independence of the judiciary but public perception. So your friend is absolutely right on that. What was the second part of the question? I missed it. Okay, I'm sorry. It was concerning judicial, Justice Muralidhar. Not
Yes.
just Muralidhar. We had another judge. I'm not going to name. I shouldn't have named because I think I have some sort of contacts with Justice Muralidhar. So leaving aside that, transfer has been a problem. Transfer has been problem, and the blame goes to both executive as well as judiciary. Judiciary has not been very clean in their dealing with transfer procedure. Transfer has been used as punitive measure. We all know what happened with Karnan, PD Karan, and many others. There are and one of the very bright judge resigned because she was not in a position to take the offerings that were made by the collegium. So a problem lies there. So certainly, when the executive branch know that you could be bent, they will bend you, isn't it? So that's the reason why independence includes integrity. So very important. If you are put on a bullet on a gunpoint, a judge who is independent, individual who is independent, really independent, he will not succumb to that pressure. In a emerging democracy like India, judges, especially the judicial leadership, will come under such pressures. That's the reason why I said we are not a perfect democracy in any sense of the term. There will be pressures, but then the best judge, what they do, they stand up to those. That's the reason why we still remember Khanna, isn't it? Why? Because he stood up to the challenge. So certainly, Muralidhar or many other transfer cases, we could sort of trace out the executive pressure on the judiciary, or there is a strong perception of it. But then who is to blame for this? It is, of course, judges, because you are bound to stand up to the executive by the very oath you take. You have taken oath to uphold the constitution. It means you will not succumb to the pressure from any walks of or any quarters of public administration or your own biases. That's the essence of judicial independence, and that's the reason why judicial independence is basic structure. Independence of constitutional institution is so very important. Our election commission, CBI, all important institutions in the country are to be independent, and judges, especially because it demands higher standards of objectivity, they should be more independent than anybody else in the world. Even compared to the gods, the judges must seem to be more independent than God, isn't it? So because God is not accountable to anybody else, and there is no, he won't fear the perception. Even if you say, Lord Shiva, you are bad, he don't care, isn't it? So there is no fear of perception. Unfortunately for us, because public confidence sort of legitimizes our authority, isn't it? That's the fodder that we have for lunch and dinner, and we sleep with it, isn't it? That's the reason why it is very important for our judges to not to succumb to the pressures, political or of any other nature. That's very important. So blame goes to the decision makers in the judiciary, unfortunately.
Thank you, sir. I believe that's the end of all the questions, and sir has addressed all the questions here. I'll pass on to Bharat. Thank you.
Thank you, sir. Thank you, Sagar. I request our principal, Dr. J. Mallikarjunaya, sir, to kindly speak a few words at this juncture.
I think good morning, Shiraj.
Good morning, sir.
Am I right? How are you keeping?
I'm good, sir. Thank you so much for asking me that question, because these are challenging times for all of us. I'm with your grace and your ashirwads, I'm doing well.
Great. That's really great. It was a fantastic opportunity to hear from you. It was indeed very intellectually well packed and highly provocative, I should say.
Certainly,
And-
sir. Yeah, certainly. Say, because sir, please continue. I'll not.
Please don't mind. Please don't mind. You can, because I need to justify. Having said it was highly provocative. You did provoke the young minds with the right questions, which every sincere student of constitutional law should ponder over. Hence, I congratulate you for your purpose being served. You have provoked them very well with the right questions as the students of constitutional law. And I was, in particular, very happy to hear from you about the myth of judicial primacy. In fact, judiciary should have a last word and should come at the end. Unfortunately, the last word is coming at the beginning in our system. I am in full agreement with your observation, and I really appreciate the aspect of judicial primacy, which you called a myth indeed. And I must tell you, I also teach these days research methods. And I'm very passionate of telling my students about two values of a researcher, namely objectivity and value neutrality. In every talk of yours, I could see that cutthroat arguments with objectivity, at the same time being value neutral when you make some statements. I was really happy to see such performance. And last but not the least, a sort of question I have in my mind, since you have been delving into this subject at such great length, bringing in a kind of code of conduct, code of discipline, etc. for the judges in any legal system is necessary. And that, in my humble opinion, would solve, if not 1/10, maximum 1/3 the problem. 2/3 the problem rests with judicial conduct of judges and not personal conduct. And that is where the complete distrust for the executive, trespass over executive functions, trying to think that wisdom of the executive doesn't match wisdom of the judiciary, and integrity of the executive doesn't match integrity of the judiciary. All these things, rather wrong things, which I consider would fall within the domain of judicial conduct of a judge. how do we address these? My own, if I think loud, I believe addressing this is only by way of bringing in a culture of lesser interference with other bodies and try to have a last word and not the first word. And this has to be brought in as a matter of culture and not as a matter of rule through code of conduct, etc. This is what I humbly feel about the matter. Since you have been delving much into this subject, I request you to throw a little light about this conundrum kind of thing. Thank you.
Thank you so very much for your encouraging words. Your blessings are always with me. Coming to your questions, very important two questions. Number one, I will talk about how and why I think comprehensive judicial conduct codes would help us as a society. Two things it does. Number one, for us commoners, we will have a sense of what we expect from judges by reading codes, isn't it? He should be sort of open, honest, impartial. He should act with integrity, diligence, probity, all that. And what a good code of conduct does is that it further outlines the guidance or the conduct required of a judge. So what it comes with a package called guidance. Okay, if you have a problem with respect to this, consult this person, he's expert in this. So what other jurisdiction have done, we should do is that we have to come up with a comprehensive code of conduct, and apart from that, we have a supportive environment. There should be somebody else helping me out. See, this is what my dilemma is as a judge, so how you should guide me in this situation. So that support environment should be there. So the first thing we have to do is to reassess what is the role of a custodian. We call our high courts as a custodian. Then what a mentor, what a father figure in a particular work environment would do to sort of to support the competence, to enhance the competence, integrity, and independence of my fellow junior judges who are the future of this country in terms of judicial hierarchies, so to speak. So I would do, sort of go with judicial education, judicial training, peer contribution, talking to them. These informal mechanisms of interaction are also helpful, but these informal mechanisms of interaction should have a certain foundational background or foundational basis. That's the code does for us. So at the one hand, public is benefited. At the other hand, the judges themselves are confident to make assessment of their own conduct, isn't it? I'm taking 2 bottles of liquor in a train while going to my home on Saturday, whether it is a misconduct. I asked this question to a bunch of registrar vigilants who are responsible to make determination on. You will find curious, the finding was that almost 50% were, almost half of them were divided on this answer. So the thing is, what is right answer or a wrong answer? The question is consistency. Do you have that message? Do you have that message right? Do you know what constitutes misconduct, whether as a judge or as an accountability account holder, isn't it? So as a register of vigilance, I should be able to make consistently that this is a problematic conduct. But that is not possible because he is also a judge. He is a senior judge, but nonetheless judge. He has his own sort of ambiguity with respect to what judicial misconduct constitutes. And I should, since you have brought such an important question, I mind taking some time on this. Now the question is how we should go about distinguishing conduct which is corrupt, which you highlighted, very, very important thing. So there are 4 layers of judicial conduct. Let me sort of figure it out for the audience here. Number 1, corrupt, pure corruption, influence, pandering, taking money, pure corruption, criminal, isn't it? So the second level is misconduct, which is criminal in nature, which is not corrupt per se. For example, let us take example of, as a judge, I abused my power and I appointed some incompetent person. You would not say it is merely a misconduct because I have abused my power. So I should be punished in accordance with the criminal law, but there is no provision exist in the criminal law. So I call it as criminal misconduct in office. This is not my innovation, but this crime existed in common law world for centuries. but we forgot it. Sadly, in UK also they forgot about this innovation. So once again, that understanding has to come up, because when you give too much administrative power, there are bound to be mistakes. And I can frankly tell you that there will be abuse of power as well. So when you allow your judges to do a lot of administrative work, there will be misuse of fund, misuse of misappropriation of property, all that. So at the one hand we have corruption, at the second level we have criminal misconduct, punishable but not so severely compared to corruption, but nonetheless criminal misconduct. And the third level, your question emphasized on this misconduct. Now then, what is misconduct? Misconduct, to make it very simple for the students community here, let us say we have comprehensive code of conduct, which the conduct which contravenes that code of conduct should be considered as misconduct. To make it very clear, comfortable for the regulator as well as regulatee. So misconduct. And you raised very important question here, how I should sort of figure out what judges do as a judge whilst writing his judgment. He is bringing his own nonsense into the readings of into the text of the Constitution. What I should do? It is clear case of misdemeanor. We call it as misbehavior to cover up many aspects. So to answer your question, absolutely, judicial misconduct, conduct of that sort are punishable and punishable with impeachment. Because as a Supreme Court judge, we have conferred ability to sort of redefine, create new rights and liability on individual. You should know that delegation has come with the responsibility to act in consistence with the values enshrined in the Constitution. If you are sort of bringing your own individual proclivities, it means you are sort of taking for granted the rights and liberties of the individual, which is a misbehavior to say the least. So such judge should be thrown out of the window through impeachment or other processes, effective processes that we need to put in place. So this is, I'm so sorry I took a lot of time, but the first part of it.
Wonderful.
Sir, a second part of question, I missed this because there was poor connectivity. It was relating to professionalism, but could you please sort of rephrase it for me? I'm so sorry, I missed it.
I think you covered it under the last aspect by saying you call it a misbehavior, a misdemeanor. That was my question. When a judge, while performing clear judicial functions in the name of upholding rule of law, goes to do something which is really not in support of or upholding judicial restraint.
Yes, sir. I'll sort of add on to what I said. Because as you said, I study different jurisdiction. So there is an interesting case study of European Union. What they do is when they come up with such questions where they see that this person is abusing judicial discretion, not just office but judicial discretion, then what they do is they refer such cases to a tribunal, and then before tribunal, judge has to justify his reasoning. His reasoning assessed there. If his reasoning is so flawed and his conduct is repetitive, they will take disciplinary action against them. So one mistake excusable, second mistake sort of creates suspicion, third mistake you should be very sure you are going to sort of ask to justify your reasoning. Because when for example, very recently I wrote a piece about this, very brief piece though, a POCSO judge. We all know what happened. A POCSO judge sort of misinterpreted POCSO Act, acquitting a couple of accused person, and then that lead to extension of her additional judgeship, Justice Ganadewala of High Court of Bombay. The problem here is that the collegium, without hearing her, why she come to such a so-called outrageous outcome, why she sort of misunderstood or misinterpreted POCSO Act. There was no sort of hearing. You should hear the judge first. what is the problem with the judge? Why his personal conviction you think are coming in the way of adjudication? You should hear the judge. You try to understand whether really there exists a gap in the procedure of assessment or appreciation of evidence. Sometimes it is so very important that we understand the implication. We don't understand the implication of procedures that we follow. We make determination or perception or opinion of judge based on the media cutouts. So let me make it very clear. When you read especially trial court judgment, what you don't see is more than what you see on the paper, isn't it? Appreciation of evidence is such a tricky thing. So that's the reason why whenever you come across a judge whose judgment seems to be very outrageous, contemptuous, we cannot just handle it. But the question is, do I know enough about this particular judge and judgment? Question involved, arguments made, evidence brought, whether evidence was admissible, to what extent convincing, all that question has to be made. That's the reason why the best thing to deal with such situation is to refer it to more senior judges. Let judge justify his reasoning, why he or she come to that conclusion. If you think that her personal views are consistently coming in her way of adjudication, then let her take go into the politics, because she strongly believes in her own personal views, which is not coming in the way of constitution. So such judges should be sort of resigned, or disciplinary action necessary. Thank you so much for asking such a profound question. Yeah.
But indeed, wonderful suggestion that we have come across. Wonderful suggestion that is. Thank you.
Thank you, sir. I request our IQAC coordinator, Dr. Manoj Kumar V. Hiremat, sir, to kindly speak a few words.
Hello, Shuraj. Hope you have time to.
Certainly, sir, I have time. And I must tell you another thing. For last 15 days, I have not spoken to anyone else. So I have plenty of time. I have plenty of gas left in. I can go on hours and hours. So no problem.
You can exhaust all your quota of 60 days.
Yeah.
Okay. Quick questions I have. You spoke about the accountability or the efficiency and all such things with respect to subordinate judiciary. And you know the recent development in India, they have done away with the experience to get appointed as a judicial magistrate or so. A fresher, a 5-year degree or 3-year LLB degree student can very next year can become a judge of the civil court and undergo just a 6 months training. Don't you think this is one of the developments that is hampering the efficiency or maybe other such things in the lower judiciary? That's one thing. The second thing is whether this long standing proposal that there shall be Indian judicial service, can that be a solution to some extent to address this insubordination or maybe a kind of a feudalistic attitude that is existing with respect to high court judges, with respect to subordinate judges? These are two things I wanted to know. And one just a quick observation. Other day I was just going through the Supreme Court judges list, sitting judges. I just out of curiosity, I verified who is going to become a next CJ and who all are going to become a CJ of India. For my surprise, out of 29 sitting justices of the Supreme Court, hardly 3 are going to become a CJI. Remaining 27 are going to retire just as justices of the Supreme Court. So I saw some, I suspect there is some politics involved in this, so that only so and so will become a CJI and rest of will just retire as a justices. So these are the three things.
Sir, one request is that if I forgot any of the questions, please do remind me. Yeah. To sort of use the last question first, question, because I have good recollection of the question. Number one, this is very interesting question, and insiders know it better than me, but this is the fact. As an executive, you can't do much about the judiciary, isn't it? So what you do is you try to control the judiciary at the beginning, isn't it? Who is going to get admission into this class 2020 and who is going to be captain of the ship? It's very clear. And this is one part that executives certainly plays. There is no denial of it. So there is a politics involved. The second thing insiders know better than rest of us is that there is a significant contribution of high courts as well as collegium to this practice. Let me elaborate on this. So what happens, let us imagine that I'm a high court judge, a chief justice. I'm never going to be, but imagine for the sake of this explanation, what I do is if I have some favorite candidates while preparing the list, I know how to play with it, and I sort of recommend accordingly. Sometime we and collegium together sort of manage the list, who is serial number 1, 2, 3, who can manage that. So that's one part. And another important thing is that there are certain high courts. This is going to be quite little bit controversial, but nonetheless has great. I have some evidence to support it, so I'm going to speak anyway. Is that some high courts have this tendency to sort of monopolize chief justice seat. For example, Bombay. What they do is, this requires extensive study. This is a hypothesis I have, is that they start promoting judges at the early age. They pick up the lot at the early 44, 45, 46, 47. And there are certain traditional high courts, they wait for person to at 50. So these judges, I should name somebody. I'm not going to name somebody. What they do is, there is uncle practice. You refer my son, I will refer your son, somebody will refer. So there is lobby, there is a tap on the shoulder. Okay, they know instinctively in bar politics come into play. And somebody asked me this question, whether the incompetencies, biases in the bar affects or whether they are affects the bench. Obviously it's very simple. Bar controls the nomination to a great extent. Bar is very powerful, and one of the reasons that explains why there is one seat of Supreme Court and not many is bar, self-interested bar. I make the statement with responsibility. If there's anybody to challenge, you are welcome. But the thing is, the bar makes important contributions in the sense that they tap informally on the shoulder. There is indication there who will be the next person, and they will push through those candidates on serial basis. Sometimes there is politics, sometimes they get disrupted, but mostly, especially, I will name the High Court. I have seen this tendency in Bombay High Court, and you will see the reflection of it, the number of chief justice we have from Bombay and presidency high courts. So what I'm trying to tell you is that at the one level, executive branch is contributing to the problem that you have noted. Judiciary is also contributing to the problem that you have noted, collegium as well as high court. And last but not the least, in one or the other way, even the bar makes contribution. Because let us say I'm just 44. If there is a nomination, bar is so powerful, they can object. Why you are making such a junior judge as a judge of the High Court? We have so many potential candidates. And invariably, if there is a strong opposition, that candidate name will be dropped. Isn't it? We have such a strong bars in this country, and that's good thing. Because a bar is also one of the account holder of the judiciary. They see judiciary at work every day. They know judiciary better than any of us sitting here. So there is accountability there. So without acquiescence of bar, such practices cannot continue for long. The fact that a 44-year young person can be promoted in one jurisdiction, and on average, in some jurisdiction, a person takes around 49, 50 years, tells you the story who is going to be the chief justice there. Because it is a law of average. Whoever has a long duration tenure at the Supreme Court, somehow one or the other day will get to the chief justice seat. So there is politics involved. Absolutely, there is politics involved, and politics of different kind, of different dimension, involving different players in the game. So I hope this answers your question. Coming to all India service and issues concerning subordination, absolutely, all India service could certainly put a break on feudal mentality that we see in judiciary. This feudal mentality is very severe because judiciary, as we know, is a closed work environment, isn't it? Judges control, this high court controls everything, so you can't do much about it. But the thing is, whether the idea of all India service is just certainly on this this aspect is justified, but then whether it is tenable, whether it is necessary, because we are a federal country. Now the question is, the thing is, we have all India service, we have all India revenue service, foreign service. There are so many services. Why not have judicial service? What is your objection? The main objection is this: administrative department or administrative branch operates with certain policy driven by the executive branch. I cannot have my own ideology. I have to go with the political executive. So the requirement of objectivity, the perception of people about the collector, and compare that perception of people to a district judge. See, I want district judge who understand my language. I want district judge who understand my emotions. I want district judge who treat me like a human. We want a legal system, judicial system, which is more human. The question is, it's not about whether in all India service serves a better way, but the perception of the public. Whether Karnataka person living in Bambalwar, Chikkodi Taluk, who is illiterate, when he knows that the judge do not know my language adequately, what would he think about the judge? This has to be addressed for two reasons. Number one, our judicial system is already sufficiently de-alienated from the masses. Okay, we are so sophisticated, we discourage our poor litigant. I am a son of a poor mother from a very remote area. I know better, Mallikarjuna sir know better about this situation than anybody else present in the room, perhaps. See, 95% of the litigation that we see, when Mallikarjuna sir go back to his home town, there will be some people coming to him, this is the problem and how to go about it. And he would say, yes, this is the way forward. So when I go back to my hometown, there will be some people, I will be helping them out. And what we are doing informal justice administration. So 95% of the cases, civil cases at least, do not come to the court, and we are messing up with 5% of the cases. Why 95% of the cases are not coming to the court? Number one, they don't think we are fit for the purpose. Very simple. They don't have money. They don't know persons, lawyers. They don't want to get involved in this court procedures and processes. So we are already sufficiently de-alienated. Our judiciary needs enough democratization. Access to justice is a myth for many of us. Even if I have a case, first thing I do as a PhD candidate at Durham University, try to compromise. Is the reality of all of us here, isn't it? So why I'm doing that? Not because I don't have a sense of justice. I have no inclination or a drive for justice, but the thing is, it is difficult to get it. So now imagine the situation. You have a judge, all India judge, Uttar Pradesh, impartial, with integrity, with sufficient robust knowledge of law. But how about this poor litigant and his perception of justice? Isn't it? So I support the idea of all India service, but then we have to assess ourselves with an open mind from the perspective of access to justice, access to courts, perception, public perception. So that should inform us. So if we come up with all India service, we should make sure that we address these gaps in the first place, isn't it? And if we are able to address those gaps, certainly all India service, for example, in Bangladesh, they have this all India, sort of nationalized judicial service, and it is effectively working well. When I interact with Bangladesh judges, I see they are more professional, competent than compared to judges in India. The thing is, they are very competent. They are very competent because they face exams in the scale, the type of like IAS exams and all. There is rigorous examination, training, and all that. And the third question you talked about, continued judicial education, isn't it? This is a fact of our country. We are essentially a feudal country having an egalitarian constitution, isn't it? So contradiction with constitution starts from our home, isn't it? Women's rights, issues relating to women's rights, many problems. The problem starts with the home. So there is inherent contradiction with the way we think, approach our life and the constitution that we have. So as a result, even in judiciary, there will be some contradictions. So for that, we have to sort of recalibrate our judicial personnel with continuous rigorous training. And that's the take-home message for whoever is still on the line here as a students, that whatever you think, it may not be consistent with the constitution. And why it is so important to sort of align your ideas into constitutional ideas enshrined in the constitution, because you are going to be an advocate or a legal profession. What you think right may not matter, isn't it? If you think that I'm right, you are going to depend your client the way you think right, isn't it? So that's the reason why it is very important that we have a critical perspective even to the constitutional foundational values. There is no denial of that. We are human beings. We have to challenge the concept that we have agreed upon. For example, secularism, the kind of secularism that we have, we will go on debating it. But at the professional level, as a servants of justice, we have to uphold the constitution values till the time they are changed, isn't it? When we change the constitutional value, which better reflect our society, then we will act once again consistent with those values, even if there is a minor disagreement with those values as well. So this is a process of social transformation in an essentially feudal society with a constitution which is egalitarian. So we all know that constitutional framers saw this picture very clearly than most of us. They knew the contradictions, but then they hoped for the better. They trusted us, the next generation, they will do better than us. And quite frankly, for a couple of decades, first 2 decades were encouraging, if not the best start we got, it was an encouraging start. We messed it up for reasons we best know. And that's the reason why it is really our obligation to reflect upon whether we as a professional, judges, lawyers, students, academics, do we interpret, do we sort of try to implement or follow the constitution as in the spirit, at least in the professional level. And when you start questioning yourself, you will question your own practice at the home. So it takes time, but nonetheless, this is the right approach, I think. Yeah, I think I answered the need for continued judicial education. Yes, of course, there is a need, and there is a rigorous need. We do 3 days, 5 days, 7 days program. Obviously, we all know they are inadequate. We need a very rigorous judicial education. Judicial education, it's not a training, but you facilitate young or for that matter, judge of the Supreme Court to be open to new ideas, to be open to new perspectives, challenge your own understanding of law as well as understanding of life. So judicial education is necessary. I think our friends present here, they will take this home, that whatever they are learning, it's just a starting point, and you hardly know anything about anything in life. So that's the reason why we have 5 years LLB course. It is just to know that we are not sufficient, and whatever you know, it is not sufficient. This is continuous process, and same goes with judges as well. Thank you so very much for that question. And All India service, obviously I have my own views, but I kept them aside to sort of highlight the right position. And coming to politics, obviously I think I answered the question. Thank you so much very much for those important questions. Yeah.
Thank you, Shivraj. Maybe there will be a formal vote of thanks, but however, let me thank. You just responded over one message and readily agreed to address our students. Thank you so much.
Let me briefly respond to this. Kaylee has been incubator for me, isn't it? I've been a student. Mallikarjuna sir know my personal positions, my situations, my background. It's important that I understand. I keep in mind that where I come from, what are my roots. So, not just this meeting. Any day, anytime, Kaylee, I will be there. So take it for granted, because
Thank you
not
so much.
because
Thank you so much.
not because I'm helping, but it is my responsibility. This institution has helped shape me, and I should tell you this: I'm a son of a very courageous mother and a student of very dedicated teachers, and I'm product of it. So it is my duty. I respond to every time you call. Every way I can help my institution. And help everyone and help myself with that. Yeah.
I must tell you, Shivraj, honestly, very honestly, I must tell you, I am falling short of words. Words are insufficient for me to express how proud we are, how proud your Kaylee family is about you. We can't express that in words. We are very proud of you, and we really look forward to be associated. Thank you.
Thank you so much, sir. Thank you so much. Thanks. Thank you very much. Take care. And for the students, this is last announcement. Please circulate my request about the responses. And if you have any questions, there is email. Do feel free. I will respond. I will take time because I'm a little busy nowadays writing thesis and all. But nevertheless, I make sure that I respond to you. And if there is, let me make it very clear, if there is any way I can help with your ambitions, education abroad, your guidance with respect to how to go about research applications, LLM opportunities, all that, you have your friend here in UK. I think I know a little bit about the processes, the procedures, and what universities in UK look for in a candidate. So I can help you with that as well. So feel free. I'm your brother, your senior member of the family. I will make sure I help you. So with that assurance, I will leave with that. Thank you so very much.
Thank you, sir. Now to deliver the vote of thanks, I hand over the platform to my friend Sachin of First LLB. Over to you, Sachin.
Good evening, everyone. I'm Sachin P. from First Year LLB of Kaylee Society's Law College. I feel elated to offer the vote of thanks to our speaker for this remarkable webinar that marked another milestone in terms of the insights we have been gaining through a series of webinars hosted by our college. On behalf of my college, our beloved principal, the entire Kaylee family and audience here, I would like to extend heartfelt thanks to our speaker, Mr. Shivraj Huchnavar, for accepting our to deliver this lecture on judicial independence and accountability and for providing with us with valuable insights. Thank you, sir. It was truly an enriching experience to learn from you. And I would like to express a profound gratitude to our beloved principal, Dr. J.M. Mallikarjuna sir, for his constant presence and for keeping us motivated with his support and guidance. Sir, we celebrate your leadership. You continue to be an inspiration in every walk of our lives, sir. I would like to thank our IQAC coordinator, Dr. Manoj Kumar V. Hiremat, sir, and our academic coordinator, Dr. Anita ma'am, for meticulously working to make academic engagements a joyful and a fruitful experience as always. Last but not least, I would also like to thank our Xenia ma'am for our faculty coordinator for giving us an opportunity to host this webinar. Have a great day ahead, all. Thank you.
Thank you.
You guys, well done.
Last words, pleasure was mine. Thanks to Manoj Kumar sir as well as Gina and Mallikarjuna sir for presiding over. It is a delight and it is a special privilege for me. So once again, it was my pleasure to be part of this exercise. Thank you so very much. Bye.
Thank you. Bye-bye.
Yes, sir. Yes, Gina, we could end the meeting.